Hello, welcome everyone. Thank you so much for joining us here today for this CIL seminar on compensation and valuation in investment treaty claims, how to account for climate change. This is the second installment of 6 in this seminar series on climate change and investment. I am Marie Lapuno, Research Associate at the NUS Center for International Law, and I will be your MC for today. We are fortunate to hear from 5 distinguished panelists today, after which we will have a discussion where there will be an opportunity for the audience to ask questions through the chat box. I will now hand over the floor to our moderator for today, Jansen Calamita, Head of the Investment Law and Policy Team of the NUS Center for International Law and Research Associate Professor with the NUS Faculty of Law.
Thank you very much, Rela, and welcome to you all. I'll start off by giving a few opening remarks, which tries to situate our seminar for today, and then introduce our 5 distinguished speakers before passing things to them. I think it's fair to say that but for the possibility of substantial damages awards, far fewer people would take notice of investment protection treaties than they do. To adapt a phrase used by the Clinton campaign back in 1994, it's the money's stupid. And in this respect, investment protection treaties and investor-state dispute settlement are unique when we compare them to other systems of law, whether international or domestic, that are concerned with private property. In investment protection treaties, we currently have a regime in which the state's violation of fair and equitable treatment, for example, or the commission of an indirect expropriation through regulatory change or through procedural failures, will lead to a quantum valuation in which the investor is to be entitled to compensation covering, quote, any financially accessible damage, including loss of profits, insofar as established, to use the words of Article 36(2) of the Articles on State Responsibility. On the other hand, if we look at different legal regimes that address the protection of private property from unlawful treatment by the state, not only do we find that liability is unlikely to attach in many cases in which a breach of an investment treaty might be found, but even in the event that the state is found to have violated its obligations, the compensation available to the investor will not be based upon the broad ideas of valuation found in customary international law, but rather on far more limited conceptions of the state's responsibility. And whether that be just satisfaction under the European Convention on Human Rights, or even non-pecuniary compensation available through judicial review in many domestic systems of law, whether in Europe, North America, or Asia. So compensation and valuation in investment treaty claims is different. And as has been well noticed, the size of these claims and awards has been growing steadily. Where awards of more than $1 billion were once considered exceptional, today awards in excess of that amount are no longer unusual. From a systemic standpoint, it's remarkable that while the contents of investment treaties and the reform of substantive protections and standards and dispute settlement mechanisms have been a matter of accelerating attention and reform by states over the past 20 years, standards of compensation and the calculation of quantum have remained virtually untouched. And so in investor-state cases today, what we see are tribunals that continue to confront treaty text that's remained virtually unchanged since the early days of the regime. An express standard of valuation for direct expropriation, equating to market value compensation, and silence as to the standard of compensation for everything else. This inaction and the application of the regime as it currently stands, raises particularly acute issues in the context of climate change. And that's our focus today. Under the Paris Agreement, as many of you will know, states have pledged to limit global warming to 1.5 to 2% centigrade above pre-industrial levels. And achieving this goal, of course, is going to require extraordinary shifts in economic activity, particularly investment, as states try to adjust economies and societies to eliminate carbon-intensive activities and shift towards Paris-aligned ones. And here we're talking about phase-outs of fossil fuel, the imposition of carbon pricing and taxing, incentives for development and production of renewables, and so forth. Each of these measures will likely have profound economic implications for investors. And as said in the program flyer, there will be winners and there will be losers. It's against this background that, and the concern that investors may invoke rights under investment protection treaties, that we come to our seminar today. Concerns about excessive awards, either diverting scarce capital needed for climate mitigation and adaptation, potentially dissuading states from adopting climate mitigation measures out of concern over potential investment treaty claims, so-called regulatory chill, and the possibility of unjust enrichment of investors in industries which have historically been able to externalize the climate costs of their activities, often with an awareness of the climate effects of those activities, it turns out. So that's what we're going to try to address in today's seminar, and we have 5 really terrific speakers to help us get at some of the issues raised. I will introduce them briefly in the order that they will be speaking. Their extended biographies are available online. We'll begin with Professor Martins Peperinskis. Martins is a professor at the University College London Faculty of Law. He is a newly minted member of the United Nations International Law Commission as of 2023. And in the field of investment law in particular, Martins is a member of the ICSID panel of arbitrators. As an academic, Martins is the author of one of the standard investigations of the International Minimum Standard and Fair and Equitable Treatment, published by OUP in 2013. And in the context of today's discussion, he is the author of the recently published Crippling Compensation in the International Law Commission and Investor-State Arbitration in the 2022 ICSID Review. Our second speaker will be Professor Emma Aisbett, Associate Professor at the School of Law at the Australian National University and the Associate Director for Research for the ANU Grand Challenge Zero Carbon Energy for the Asia Pacific. The Grand Challenge is a project that aims to provide research and engagement in order to facilitate a rapid, a just, and a sustainable transition to zero carbon energy in the region. Of particular relevance, again, for our discussion today are 2 articles that Emma has written with our third speaker, who I'll introduce in a moment, Jonathan Benicia. The first is a Pareto Improving Compensation Rule for Investment Treaties, published in 2021 in the Journal of International Economic Law, and an award-winning paper for its innovative approach to rethinking compensation in investment treaty claims. And also a companion paper, also with Jonathan Benicia, Against Balancing Revisiting the Use Regulation Distinction to Reform Liability and Compensation under Investment Treaties, This published also in 2021 in the Michigan Journal of International Law. Our third speaker then following Emma will be Jonathan Venetia. Jonathan is Associate Professor at the University of New South Wales. His research is interdisciplinary, combining law with economics and political science. Jonathan has worked both in academia and in practice with the Attorney General in Australia in the Philip Morris case, as well as an advisor to the government of Myanmar on investment governance. He's the author of an economic analysis of substantive protection under investment treaties with CUP in 2014, and co-author with Lauge Paulsen and Mike Wabel of Political Economy of Investment Treaty Regulation in the Investment Treaty Regime, rather, in 2017. Our fourth speaker is Professor Rick van der Ploeg. Professor van der Ploeg is Professor of Economics at the University of Oxford, where his research focuses on the economics of climate change and the economics of resource-rich economies. He has held posts at a number of distinguished universities, including Cambridge, the LSE, Tilburg, and the European University in Florence. For our purposes today, of note is his 2020 article on stranded assets in the transition to a carbon-free economy, published in the Annual Review of Resource Economics. And last but by no means least, our final speaker will be Dr. Boaz Mosel. Boaz is Executive Vice President at Compass Lexicon, based in London and Paris. He's an economist who's worked in academia, consulting, and government. His areas of expertise include oil and gas, other types of energy resources, and regulated infrastructure, focusing on economic analysis relating to pricing and valuation. He's offered expert testimony in approximately 50 international arbitration, and he began his career as an assistant professor of economics at Northwestern University. Again, as I say, please consult the online resources for further information about our 5 very distinguished speakers. But it's enough in terms of me talking. Let me start things off by passing to our first speaker, Martins Peperinskis. Martins, would you like to take the mic?
Thank you, Janssen, and thank you for the kind words of introduction, and thank you to you and Rail for having me, and Jerry behind the scenes, as always, keeping the wheels on. My mandate has been to speak on the articles on state responsibility, the 2001 International Law Commission's articles on state responsibility for internationally wrongful acts in general terms, so to speak, to set the scene on the way how public international law governs the issue of compensation, and say something as well about my argument of the possibility of conceptualizing an exception against crippling compensation in investor-state arbitration. I will make 4 points, or at least will try to make them. When 15 minutes come, I will just stop before Janssen starts nudging. I will first say a few words about the general structure and the nomenclature of the articles, then suggest a few slightly subversive points that perhaps they give a bit more flexibility than is sometimes fully appreciated. Then I will spell out certain ways how that flexibility might be implemented, and finally say a few things in the conclusion about the particular point of crippling compensation. So I think to get onto Janssen's observation about increasing size of damages award. So, by way of background, the International Law Commission is a subsidiary body of the United Nations General Assembly, tasked to engage in progressive development and codification of international law. So, not a lawmaker, as it were, ex officio, but many of its outputs are thought and perceived by states and international judicial bodies as reflecting customary law. And one of those that is particularly influential in the last decades is precisely the 2001 ILC articles. Still, I think, subject to some debate in the August settings of the General Assembly for the last time, just last year in the Sixth Committee, where states again agreed to disagree whether articles should be moved to a convention. Now, if we look at the rules on compensation, we see that they are expressed in Part 2. And ILC articles, analytically, as many great projects in human history, are divided into 3 parts. Part 1 tells us about international wrongfulness and responsibility. Part 2, content, and Part 3, implementation. And we are interested here only in Part 2, where a number of articles are expressed throughout this part that relate directly or indirectly to compensation. In particular, Article 36, from which Janssen quoted in his introduction on compensation, Article 31 on full reparation, and particularly on causality, was important commentary on mitigation and contribution. Article 38 on interest, and Article 39 on contribution to injury. Now, there is a puzzle in Part 2, something that was not always fully appreciated or at least acknowledged in the early investment arbitration practice, that Article 33, paragraph 2 appears to limit its scope to interstate responsibility, as it were, responsibility accruing from a state to another state actor. And paragraph 2 provides a without prejudice rule to responsibility accruing to non-state entities, which the commentary confirms in commentary 4 as also applying to investment arbitration. But it seems to me that if we look at both the way how particularly Article 36 was discussed within the International Law Commission, if we read through Crawford's third report, the general discussion and authorities that were relied upon, as well as subsequent endorsement by judicial bodies in various settings, not only investor-state arbitration, but also other contexts where non-state entities invoke responsibility in regional human rights courts. In particular, it seems broadly accepted that Article 36 is one of those provisions which would be also applicable as a general proposition to responsibility invoked by non-state actors. I have also argued, and that is something that will be forthcoming in a project, hopefully to be published later this year, on commentaries to commentaries of the ILC article, the sort of post-glossatorial tradition, as those attuned to history of Roman law will appreciate, where I am writing on Article 36, and my sense is that overall it is reflective of customary law, even if paragraph 1 perhaps a bit more strongly than the second one. So this seems to be broadly applicable law. Let me now move on to my second point and make 3 slightly subversive points about how articles on state responsibility provide tools rather than a straitjacket. The first is that the story of development of rules on compensation in state responsibility, often told by reference to the mythical, much quoted words of the Horseshoe factory case in the Permanent Court of International Justice, is a bit too Whiggish history for me. If we look at the way how permanent courts case law was perceived by states and judicial bodies in 1930s as well as later, it really didn't have much of an impact or even a splash. It was not treated as reflecting any particularly brilliant proposition just 2 years after the discussion in the 1930 Hague Codification Conference. And if we look at the way how states approached compensation throughout the Cold War, it didn't really seem to be shaping practice much at all. Indeed, in 1986, Christine Gray famously asked in British Yearbook article, "Is there an international law of remedies?" In a few years, she wrote a monograph without a question mark, but that was a question that was posed and was taken quite seriously by commentators. So that was my first point, that it is not terribly helpful to try to imbue a certain mythical authority coming out of The Hague in 1920s and try to divine what might be found out from the wisdom of questions posed to experts. The second point is that if we look at the way how rules on reparation and particularly compensation were thought of within the International Law Commission in 1990s, and here I'm particularly thinking of James Crawford's third report in 1999, it wasn't really factory at Chorzów driving everything else. If anything, it was the factory being a bit apologetically introduced as being not entirely worthless. So that is the way how Crawford pitched it quite explicitly. Essentially, in late 1990s, there wasn't much in terms of recent and high-quality interstate arbitral or judicial practice on compensation. All the interesting things were happening somewhere else. Regional courts of human rights, Iran United States Claims Tribunal, a post-Iraq compensation commission, early exit arbitrations, and the most that International Law Commission could say was that we might say that they are implementing the general propositions, or they're in line with the general propositions of the Chorzów factory. So the ILC framing is not specialized rules subserving the general ones. It is rather specialized, more sophisticated regimes being conceptualized under the general frame. Now, rightly so, I think that I'm very sympathetic to the generalist framing, but it suggests that there is more flexibility rather than a straitjacket coming down from 1928. And my third point is perhaps pulling all these together. From Crawford, it seems broadly clear that his sense was certainly not that there was I suppose, a machinery bouche de droit where simply by typing in Chorzów, we arrive at a very large number. The idea of an overall balance struck by taking into account all the relevant circumstances is something that characterized his work. So that is the point that I think we need to take together with the acceptance of customary law. Customary law has certain inherent flexibilities in the way how these points are approached. Now, how do we get from this general proposition to something more particular? Let me just say as a backdrop, there's a systemic balance to be struck, of course, here as well. There may be reasons why one is sympathetic to flexibility and implementation. Equally, there are good questions to be asked whether within the decentralized system and field of investment arbitration, where the quality of decision makers and counsel varies, greater flexibility is a systemically desirable development within the applicable rules. There is perhaps something to also be said for clarity, consistency, and simplicity for the rules, not least if there's willingness to change them. So in a way, if we know where the line is drawn, it is easier to change it at the meta level. But at the level of systemic balance, I think that there are a number of elements that were implicit or explicit in the balance struck on remedies. In particular, I think three. One is skepticism expressed in the commentaries regarding certain calculation and evaluation methods, particularly discount cash flow, as well as compound interest. And secondly, ultimately, somewhat conservative approach on loss of profits. If we look at the debates, initially, the way how loss of profits were expressed in the first reading was very strongly resisted by United States, who felt that it was leading to even decodification of the applicable rules. So very strong words. And Crawford wanted to change that in a much more favorable direction. But in fact, the second reading, while having a substantively different phrasing, was not perceived as majorly moving on issues of substance. So there are certain, I would say that IOC articles probably approach calculation and valuation methods with a certain degree of skepticism. To the extent, of course, interpretation, application, and development is a normal way for international law to work, but to the extent that arbitral practice moves to undo, to some extent, this balance in one direction, it seems to me that it is not systemically harmful to think of balancing principles emerging in the other one. So I think the fact that we have seen increasingly prominent reliance on contribution, to some extent on mitigation, are examples of that. And perhaps there's even a scope for looking at more direct principles introduced de novo, like relating to crippling compensation. The only thing that I would like to note before I move to that last point is also the possibility that the very pragmatic and non-dogmatic law of state responsibility might fit within the modern multilateral setting. It may be that primary rules or standards relating to certain fields of international law might come in to flesh out what contribution and mitigation means in particular setting. And I'm thinking here as an example, the opinion by my colleague Philippe Sands in the Bear Creek case. Now, let me come to my final point, crippling compensation. This is not a claim about a positive rule currently existing, but a claim that a positive rule of this kind would be overall consistent with the systemic balance struck. So that is something was to some extent discussed in the International Law Commission, even though Crawford was ultimately deeply unimpressed and rejected it as not seeing as either helpful nor relevant. And I think my argument is that even though Crawford was right on almost everything, on this particular point, the assumptions of the reality of the international legal order of the 1990s do not really map that of 25 years afterwards. What is the contemporary law that might it be legally relevant for the decision maker to consider impact on the responsible actors? So Tetyan Copper, ConocoPhillips, and such cases. I have seen very little in investment arbitration practice so far, to be fair, although these are things that need time to filter through the system. So perhaps these arguments are being made, but they have had some traction in other settings. In 2021, Chile invoked the argument in the Profesores y Generales Otras Municipalidades case before the Inter-American Court of Human Rights, where introduced me as an expert before the court, and the court invited me. So the argument is there, even though, to be fair, the court did not seem terribly taken to it. And last year, the International Court touched upon it in the Congo and Uganda case regarding armed activities, ultimately not deciding, but leaving it open. So these are not frivolous arguments. States are making them, tribunals are at the very least taking note of them. So that is probably the point where I would like to stop, perhaps just summarizing what I said. Applicable customary law, but with some flexibility and importance of thinking through the systemic balance. At the same time, also considering the importance of predictability and clarity of rules in such a decentralized field. So somebody wins, somebody loses, no matter how we think about applicable law in the area. And back to you, Janssen.
Thank you, Martins. And thank you very much for staying precisely on 15 minutes. I look forward to coming back to your presentation and picking up some of those issues in our discussion. Let's turn to Emma as our next speaker. Emma, go ahead.
Thank you, Janssen, and thank you everyone for joining us this evening. This is a very exciting and innovative panel in itself. I really note the degree of law and economics or interdisciplinarity on the panel, and indeed I think economists may even outnumber lawyers, which might have something to do with money being the central theme. As you can tell, I am one of those economists, And I was privileged to collaborate over many years with Jonathan Bonnicher, who is an interdisciplinary legal scholar. And we, like many others, had a sense that something was a bit out of kilter with the regime, a growing sense. In particular, the extent of the awards and the size of the awards. And so we set about to take a different direction to many people, and not look to what previous legal opinion or previous sort of legal thinkers had thought about what might be a way to think about what the right damages or compensation rule is, but rather to turn to neoclassical economics, and in particular, starting with the first welfare theorem and saying, let's understand this international law in the same way we would think about government interventions. They could only help us improve overall efficiency, which is often the claim made in support of investment treaties, if they're effectively targeting some sort of market failure that is otherwise failing us and failing our efficiency. So our starting point then, and I'll go ahead and share slides, was to really try and think in this sense, what are investment treaties actually trying to solve? What is the problem they're trying to solve? Okay, can you all see that? Yeah, great, thank you. And of course, this is probably not new to anyone, either on the panel or in the audience today, but the most commonly stated argument for why we need compensation under an investment treaty is because, as an economist would say, there is a time inconsistency of optimal policy problem for the host. There is the temptation, so before an investment is made, before there are any sunk costs, hosts have every incentive to promise the world to the investor in order to get the investor to come in and to sink their costs. Once the investor has sunk costs that it can't easily retrieve back out of the country, that sort of balance of power, balance of bargaining power changes. And if you have a simple one-shot game with no repeated interactions and no reputation effects, that model will give you, in fact, a hold-up problem where the state then, its optimal policy once the investment has been made is to actually expropriate that investment and capture as much as possible for itself. So this is what we were conceptualizing as the fundamental market failure or problem that investment treaties are trying to solve. The problem, however, is that the way current investment treaty rules are designed, they can't differentiate between hosts changing their treatment of an investment ex post because of that time inconsistency problem, or because the world has changed, because we have realized that climate change really is a big problem that we need to address, for example, because we realized that a particular mine is going to have a devastating either local or global environmental effect. And as a result, the current regime can lead not only to very large claims, but can also leave hosts worse off for having had an investment come into its country. And this, of course, leads to all sorts of questions about equity in the international regime, as well as all sorts of political issues, and is the source of a great deal of the discontent with the current investment treaty regime. So I don't have the time here today to explain how we came up with this, but you know, many hours, months, years of mathematical modeling, and then very careful conversations with Jonathan about the real world later, we actually believe that we have been able to design a rule which can effectively differentiate those two things. And it can solve essentially that time inconsistency or hold-up problem without punishing hosts for changing their behavior in response to new information and undertaking appropriate public policy responses. And the key innovation that we used to do this, to disentangle those two things, is by changing the counterfactual situation. So where the current, very broadly speaking, where the current regime will say, what is the loss that the investor faces in the situation where the government has changed its rule or changed its treatment, compared to the situation in which it had not changed that treatment? That's the current sort of counterfactual. We change it to be, what is the loss for the investor compared to the situation in which the government had had that new policy in place before they made the investment decision? And this subtle change is actually incredibly effective at separating out the new information and the time inconsistency problems. We also wanted to tackle another commonly discussed issue, which is that once you have very large numbers of compensation, you start to get ambulance chasing, third party, and all sorts of perverse incentives and perverse outcomes. And so we thought carefully about how we could design the minimum damages or compensation rule that would be sufficient to solve that hold-up problem. And it turns out you can solve, in fact, the underinvestment. You don't need to solve the whole hold-up problem. You need to solve the underinvestment, the results from that hold-up problem, by either awarding the compensation that is the loss that the investor faces relative to our counterfactual, or the gain of the host. And so we have set our rule to say, we'll just make the compensation be the minimum of those two, because either of them are sufficient to solve the problem. And we want to take as much of that excess heat as we can out of the system. So the formulation of our rule in the paper is that the host should only have to compensate the investor if it breaches or modifies the domestic legal regime governing the investment, and that the compensation should be the lesser of the investor's loss and the host state gain from the host not having had the new legal regime in place when the investment was made. And that's Jonathan's superb formulation of our rule. I'm not sure how I'm going. I've got time to take you through a couple of examples, and choosing two that are of particular relevance to the climate regime. So we didn't have only the climate regime in mind when we designed this rule, but it's certainly very relevant to the climate regime. So, for example, a very famous example is the Tethyan copper versus Pakistan. But of course, there are many coal mines that are facing legal challenges and might actually get, proposed coal mines that might get rejected under changed climate regime laws. So this is a very relevant example here. And of course, the tribunal awarded a very, very large sum, nearly $6 billion in compensation. This would not have happened under our proposed rule. So thinking about what the investor loss would have been compared to the situation of it not having invested, because we're assuming that had the government, made this rule in the first place, the investor would not have chosen to invest. Then, of course, the investor's loss relative to that situation are its irrecoverable project costs to date. So, the sunk costs, as you would say. The host gain compared to the investment never having happened in the first place, it might be positive if we think that the host would have taken the information and all the sort of sunk costs of the investors and used them and handed them to a domestic proponent of the mine, or it might actually be zero if the government made no use of all those sunk costs and just kept the mine closed for environmental or social reasons. In that latter case, the compensation would actually be zero, because the lesser of the host gain and the investor's loss is that number zero if the host gain is zero. So it's a very, very different outcome to what we get under the current regime. Really importantly, so there's not only an interaction between the investment treaty regime and fossil fuels being phased out, but also green industrial policy. I'm sure you're all aware we're seeing a lot of green industrial policy, a return of industry policy, which means a lot of government intervention. And solar feed-in tariffs are an example of green industrial policy. One thing that you will note, if you've read anything on green industrial policy, is that best practice green industrial policy is a process of systematic learning. That means governments constantly need to be changing the incentives that they're offering to these new green industries if they are undertaking best practice policy. That, of course, is very incompatible with the current regime, and the Spanish solar cases are a classic example of that. Of course, here, another very large claim by solar industry against the Spanish government. Once again, our rule would have awarded a much smaller sum. So once again, considering what is the host gain and what is the investor's loss, the host gain is potentially zero. So in the Spanish solar case, the Spanish government had actually set a very generous feed-in tariff. So this was actually a very expensive way for them to get renewable energy into their grid. So they didn't really gain anything by getting all these expensive investments in and then just dialing it back to a sensible feed-in tariff. So in that case, the host gain is zero. Similarly, the changes to the feed-in tariff were, of course, advised by the International Monetary Fund, and they were advised such that a well-functioning solar development would still be profitable. So if you think about that, these investors have come in, they've first made excess profits because of an overly generous feed-in tariff, and then they've been dialed back to just make a standard, normal sort of profit rate. So these investors have not been made worse off compared to the situation where the feed-in tariff was sensible to start with. In fact, they're better off than that situation. So once again, no compensation would be awarded in this case. So just to wrap up, hoping to stay on time as well. As a result of all these innovations, our compensation rule ensures that international investment agreements, that participation in these agreements will actually be Pareto improving, in the sense that it will benefit both host countries, those countries tend to be the recipient of the investment, as well as source countries party to the treaty. Our rule effectively prevents the threat of opportunism from constraining investment, including much needed investments in renewable energy. It's compatible with green industrial policy and with ramping up of climate ambition over time in response to new information, for example, from the IPCC. And it doesn't require us to actually rewrite and rip up all of the existing investment treaties. It could potentially be implemented as a clarification on the way that damages are calculated under existing treaties. So I'll leave it there and hand it over to Janssen and Jonathan. Thank you.
Thank you. Thank you very much, Emma, for the fascinating presentation. And let me just turn then directly to Jonathan to pick up on that. And well, go ahead, Jonathan.
Thanks, Janssen, and thanks, Emma. I feel like we get a bit of an advantage here with 2 bites of the cherry, but I'll try to make the most of that opportunity and also keep it quite brief, so perhaps there'll be more time for discussion. So building on what Emma was speaking to, she had the real intellectual heavy lifting there, the kind of core insight of our proposal. I'm just going to consider one other example of a case and how that's played out. It's the case of Rockhopper in Italy, probably the most famous and widely reported investment treaty case from last year. And I'm going to use a discussion of how that case actually worked through the question of compensation as a way to clarify how our rule would apply in practice, and also to distinguish it from some other proposals or moves that have been discussed, including Martin's, to reformulate compensation in different ways. So even if I don't convince you here in the audience, I hope that exercise will also be clarifying in the way that it situates some of the different ideas here in relation to each other. So to Rockhopper in Italy, then, I think most people will be familiar with this case, even if you haven't read it, but I will go through the facts carefully just to make sure that we're all on the same page, because I'll be drawing back on these. So broadly, this was a case about a proposed offshore oil and gas development in Italy. And throughout the relevant period, the Italian regulatory framework broadly had two phases. This is very common in oil and gas. The first phase was the issue of an exploration permit, which would enable an investor, a holder of that permit, to go and engage in all sorts of seismic prospecting activities, and through a regulatory pathway that would lead at the second stage, if the investor fulfilled all the relevant regulatory requirements, including approval of an environmental impact assessment, to the granting of a production concession. So two phases in the process: exploration permit, production concession. The original investor here was Mediterranean Oil and Gas, and it had held an exploration permit since 2005 and been in the process of obtaining a production concession since 2008. So quite a drawn out process, engaged in meeting the requirements for the second regulatory stage. During that process, there'd been a lot of local opposition to the development. It was quite close to the Italian coast, within 12 nautical miles. And so the rig, I understand that they'd had out there while they were searching about in the exploration phase, could be seen from the beach. People were pretty upset about that. In 2010, there was a change to the law that banned exploitation of oil and gas within 12 nautical miles of the coast. That would have ruled out this investment. But in 2012, apparently under the threat of legal action, there was a subsequent change clarifying that existing applicants for production concessions were grandfathered, so excluded from the scope of the ban. And it's at this point in 2014 when the investor, the claimant, actually comes into the picture. So they purchase all the legal rights associated with the project, which is still at the exploration permit stage in 2014, and push ahead with the moves to obtain a production concession. In 2015, their environmental impact assessment is approved, and under Italian law, at least according to the tribunal's analysis of it, this triggered a right on behalf of the claimant to be granted a production concession. But the production concession was never granted. The process stalled as various administrative requirements were worked through. And in the background, a legislative change that came through 4 months later that again completely banned offshore exploitation of oil and gas, with the final result that the investor was never awarded a production concession. So they never got the legal right to go ahead with the project, and they never went ahead with the project. Instead, they initiated an investment treaty claim under the Energy Charter Treaty. And the tribunal saw this as a clear-cut, unequivocal, direct expropriation. So the decisive legal question for them was whether Rockhopper in 2015 had a right under Italian law to be granted a production concession, having completed the EIA process. And when the tribunal answered that question and they said, yes, Rockhopper did have this right under Italian law, they said, well, there was a legislative change, they had this right, and the legislative change terminated and cancelled that right. They described it as an immediate and complete deprivation of the claimant's investment. Okay, so we get to compensation. And here, as is common in most investment treaty cases, and I guess slightly contrary to the sort of flexibility that Martins sees in general international law, both the claimant and the respondent lined up apparently behind the full compensation standard. So that's the Chozhou-Factory standard, the idea that compensation in principle is forward-looking and loss-based, so that it must re-establish the situation which would, in all probability, have existed if the act had not been committed. As is common in these cases, the claimant argued for valuation using a discounted cash flow model, so an income-based valuation. Although the evidence is not public, apparently they modeled a range of scenarios, which is good practice, and showed that under variations in assumptions, the investment was worth something between 68 million euros and 1.59 billion euros. And for reasons that are not entirely clear on the publicly available information, they argued for 275 million euros as the valuation. The respondent argued that compensation at most should be the 36 million euros that the investor had actually paid for the complete set of legal rights associated with the project in 2014, less than 2 years before the process was actually terminated and the investment couldn't go ahead. And the tribunal accepted the claimant's broad approach that valuation should be based on the principle that compensation is forward-looking, that compensates the investor for the loss that they've suffered, but for the state's wrongful act. So putting the investor in the situation that they would have been in if Italy hadn't changed the legislation to prevent the project going ahead. And they valued that loss at 184 million euros. Okay, what if anything is wrong here? This decision has concerned a lot of people. It obviously concerned the tribunal enough that one of the arbitrators wrote a concurring opinion to explain that even though the outcome here looks untenable, in fact, it's just an acceptable application of normal investment law principles, and there was no interference with environmental regulation because the state was quite entitled to cancel this project and just pay out the investor. For lawyers coming at this, one of the deep feelings of discomfort comes from the fact that the investor here entered a sector where there was a known regulatory risk, known political opposition to the project in the context of wider moves across Europe to tighten up the regulatory framework around new oil and gas development, and then seems to have argued that even though it was never actually entitled to go ahead, it never actually had a production concession, that its rights had been expropriated in relation to that process. That's a lawyerly intuition, but for us, I think the deeper problem approaching this from an economic and an environmental policy perspective is not just about that discomfort, although that's relevant about what the investor should have foreseen. It's more about the incentives. So it's about the fact that this sort of approach, if applied generally, is very clearly shifting the regulatory risk of these sorts of tightenings in frameworks around oil and gas development back onto states and taxpayers. And more generally, and this is where linking back to the core insight that Emma was really articulating at an analytical level, this is not a problem investment treaties should be trying to solve. In fact, it's not a problem at all. This is just a regulatory risk of doing business. It's unfortunate for an investor. Investment is risky. That's a risk that they need to carry. This is not a case of opportunistic conduct by a state driven by time inconsistency in the state's underlying incentives. So our proposal would deal with this very cleanly. So recall that our proposal is that a state should only face the possibility of having to compensate if the state has breached or modified the domestic legal framework governing the investment. So for the purposes of this, let's just assume the tribunal was right, and that there was an entitlement to the issuing of a production concession here, and the state has then, if that's the case, clearly modified that by preventing the investment going ahead. But under our rule, the compensation is the lesser of the investor's loss and the host state's gain from the host state not having had this new regime in place when the investment was made. So obviously the host state has gained nothing here from not having had the prohibition on offshore oil and gas exploitation in place earlier. This is not a case where the host state has gained anything by allowing the investment to proceed and then subsequently prohibiting its progression to the next stage. So this is a type of case, a category of case that our rule deals with very cleanly. And in that way, you see that the compensation principles that we're articulating are doing a lot of work that other legal scholars tend to approach in terms of substantive doctrine and exceptions. So under our proposal, the compensation rules here are doing a lot of work to say this is just not a category of case where investors should be entitled to any compensation. Okay, so with that clarification in mind, let me compare it a bit more specifically to some of the other proposals that have been discussed about dealing with climate change within the investment treaty regime. So there has been a lot of talk about clarifying substantive standards or including more exceptions. But as we see here, this is a case that the tribunal characterized as a direct expropriation. So that's not within the normal scope of discussion of clarification of substantive standards. And in fact, I'm comfortable with the tribunal's characterization of that under the existing law. But that just goes to show that the solutions really need to be found elsewhere in the regime. As to exceptions, if we look at the detail of the Rockhopper case, you can see that the tribunal was actually really equivocal about whether this was a legitimate environmental purpose or not. It was not a question it needed to decide because there was no exception, but even if there had have been, the tribunal might have characterized this as related instead to some sort of political backlash, some local government versus central government issue. There was a lot of that in the case. Tribunals have often tried to unpick the decision-making process. And we also know from cases like Eco Oro and Colombia that exceptions are not always interpreted the way everyone thinks they should be. So none of this is a general case against exceptions. It's just a word of caution, I guess, about avoiding making the assumption that environmental exceptions can do all the work for us in the system. We think that approaching these sorts of cases from the perspective of compensation is a much cleaner way to address them and link to a wider theory of what investment treaties do. Again, briefly, because I'm conscious of time here, there have been discussions about either banning the use of income-based valuation methods like DCF altogether, or considerably restricting their use. Again, these may be good ideas at some level, but I think they are a fundamental misdiagnosis of the problem. So a criticism that is often made of DCF is that it is too speculative, that using income-based valuation methods are too uncertain. Uncertain indeed they are, but if this case, there had been a much better evidentiary record about the quantity of oil and gas, the expected revenue streams, the likely cost associated with project development, none of that sort of greater evidentiary certainty around the valuation would actually have solved the underlying problem in that case. And that's why we think approaching this question of reform just from the perspective of saying, well, we've got to ban DCF or tighten it up, while those may be relevant criticisms, we think they're potentially misdiagnosis of a deeper problem. I might say there's a lot more to say about that. I'm happy to come back to that in questions. Finally, and this is where, with the greatest respect, I am going to part company with Professor Paparinskas. I think both Emma and I are deeply skeptical of balancing approaches, or what we might call ad hoc approaches to compensation, for a range of reasons. Perhaps the biggest of these is a lack of trust in international lawyers' ability to exercise judgment in an unstructured way. So the way the regime is operated doesn't give us a lot of trust in the idea that what we need to do is just have more flexibility for arbitrators to balance up competing considerations as we see fit. But I guess the more precise, the more analytically precise problem is that until arbitrators have an underlying theory of the problem the treaty should be trying to solve, to tether that sort of exercise to, then a call for more balance or more flexibility is just a call for unstructured discretion, which is likely to go wrong, to overcompensate and potentially to undercompensate in some cases where it's actually deserved. I'll stop there, but happy to return to any of this in the questions. Thank you.
Thank you very much, Jonathan. Thanks particularly for linking the economic arguments with the legal issues that the regime faces. Let me turn to Rick van der Ploeg. Rick, over to you.
Thank you very much. I think I will take a slightly broader perspective, because that's what I was asked. It's not much to add after that wonderful presentation of this Pareto improvement rule by Emma and Jonathan. I read it. I wasn't aware of it. I read it before the meeting, and I think it provides a lot of food for thought. So I will share some slides and make it have a bit more broader perspective.
Okay, great.
Yeah, then I can make this small as well. There we go. So what are stranded assets? So from a point of view of economists, it's basically assets that face unexpected or premature write-downs, devaluations, and conversion to liabilities. In the extreme case, they may become obsolete, and they may have to be written off entirely. So typically, that may be due to regulatory change or unexpected changes in government policy. But it may also be due to quick technology life cycles. It may be due to changing social norms. So it's difficult to ascribe all of it to a change in government policy, because it may also be due to a change in technology or due to a change in social norms. So when you try to assign damages or compensation, things like that, one has to at least disentangle the various reasons why there may be stranded assets. The types of stranded assets could be, I think it's helpful to distinguish. One, there's a lot of carbon that's never allowed to be burnt. I will come to that later. That particularly relates to the oil and gas majors, and also the coal companies. Secondly, companies like steel or cement or the greenhouses in the Netherlands, they use a lot of fossil fuel, and they put a lot of investments in there. So they might have just invested in a coal-fired power station. They may have invested in a steel factory, and then suddenly the government says no longer allowed. So then they become obsolete and it needs to be written off. A third way of looking at it is that share prices will be much affected. So if there is if there's a sudden change in policy or a sudden change in technology or a sudden change in social norms, it may be that say brown firms' assets will fall. They will have to pay a higher return on their assets for people to willingly hold those assets. Whereas for green firms, it's the opposite. They might see a rise in share prices. So when we talk about asset pricing, I think it helps to distinguish those three different types of things. So having said that, I'm quite negative about what's going on. So I just thought, let's take The Guardian at the end of last year. They identified 200 carbon bomb projects. And they're helmed by Exxon, BP, and Shell, and other companies. And basically, what's going on? There's a huge exploration boom going on. I mean, this was already also before the war started in Ukraine. So there was so lots of private equity firms are pouring billions of dollars into these new explorations, whereas you're not really allowed to burn anymore. So if you want to stay below 1.5 degrees Celsius, we cannot burn more than 400 to 500 billion tons of CO2. But these reserves of oil, gas, and coal are already about 7 times bigger. So that means the temperature will rise very much above 1.5 degrees, and the world will be toasted. So they're already, and then this exploration is going on and on already on top of that 7 times. So the question is, are these all going to be stranded assets? Are these people willingly taking those risks? Do we really want to compensate those companies? So when you look at this scheme, I hope you can see that. You see that the little gray area here, that's what we're allowed to burn. And here you see all the reserves of the United States, Russia, China, Australia, India, etc., etc., etc. So it's about 3.5 trillion tons of CO2, which is kind of in those reserves if they were to be burned. So we already have reserves about 7 times as big as that we are allowed to burn. So are those companies and those oil, gas, and coal companies, are they kind of economically bankrupt? Are they very dodgy? Will they? Of course, they had an extremely good year now with the war. But from a climate perspective, that stuff should never be allowed to be burned. So then the question is are those investments that should be compensated? I would probably argue not. So many kind of very business magazines, from the Financial Times to The Economist, the Wall Street Journal, they've been going on for years, arguing that there's basically it's the end of the game, it's the end of the story. And they're warning and warning. It's a life or death question. No chief executive wants to be left holding $1 million oil fields or kind of oil-intensive assets. So it's kind of, the surprise is not really that big. So from my point of view, or from any point of view, I think the market's point of view, people are knowing that it's happening. And it's perfectly predictable that at some point of time, governments will have to flip, even if only if they have to kind of hold themselves to the international agreements of 1.5 degrees Celsius that they've committed themselves to. Indeed, some NGOs like Agenda in the Netherlands are taking companies like Shell and countries to court to kind of hold them to their promises. So in that, again, that's a kind of different type of court case that we've been talking about so far. So with that in mind, is it really all that unpredictable that those companies are investing in assets which are already kind of assets of the past? So what we will see is that to quantify these stranded assets, so we need to kind of, it's a surprise change in something, a surprise change in climate policy, a surprise change in technology, or a surprise change in social norms. But it's very important that it only applies to investments that are irreversible. I think that's partially of the argument by Emma and Jonathan if they talk about holdup problems. There are kind of adjustment costs, and it's the idea that these investments are irreversible. So the extent of the compensation will also depend on how irreversible those investments that have been made are. So that should be part of the rule. I couldn't see that as part of the rule, but I think that's an important thing. You may assume that it's completely irreversible, then it's probably easier to get a rule that will give you some upper bound on the amount of compensation. So we have all kind of tipping risks. That's another way people look at these risks that's going to happen, is about unexpected policy changes, technology changes, and societal changes. They will disrupt financial markets. They can lead to stranded assets. So it's very important, and that's what central bankers do, to distinguish between transition risk and physical risk. The transition risk is what we've talked about, whereas the physical risks are the risks that when it gets hotter, you get many more extreme events, you get many more damages. So when you look at this graph, you see that when we go to 2 or 4 degrees, we get 10 times more extreme events. Or you get more hurricanes, you get more droughts, and you get more extreme weather events. The incidence of those occurring rises steeply with temperature. So these are the physical risks. So we're not talking about physical risks. We're only talking about transition risks. So here, this is the way the central banking system looks at these things, where you have on the left-hand side transition risk and physical risks. So they also recognize that transition risk can be due to policy and regulation, can be due to technology, it can be due to changes in consumer preferences, and they have all these physical risks I just mentioned about. And then they get transferred via the economy, both on a macro level and a macro level, and then they lead to a lot of financial risk. So that's the concern of financial regulators and central banks. So you get increased credit risks, you may get defaults by business and households, you may get that, for example, if you're a steel company, climate policy is serious, then your value of your assets will become less, so your collateral will become less. So these companies are less able to borrow and therefore less able to invest in their green transition, which they need to do. There's more market risk, may even be systemic risk, there's underwriting risk, there's operational risk, and there's liquidity risk. I'm putting these things down because I think these risks are all part of the picture when we're looking at compensation schemes as well. So the oversight and regulatory authorities started with Mark Carney, but there's an important network for greening the financial system. So I think they should have those discussions we're having today as well. And they've been arguing for stress tests. So imagine that temperature is kept to 1.5 degrees. Which companies will go belly up? Which companies will lose, and which companies will gain? And might that lead to systemic risks? Absolutely crucial for that is that we don't really need it, is that I think also to be able to, if we aren't going to talk about compensation, and that for later, it's very difficult to even entertain that idea when we still haven't even started to begin the road of going towards full corporate disclosure of carbon risks. So there's a big, also the United Nations and many others are trying to get a system where each company discloses their carbon risk, and that's not really done at the moment. And without that, it's very difficult, at least from my point of view, to start talking about compensation. So first things first. So now a bit, are a lot of these risks are they already priced in the market? Well, the argument seems to be quite strong that they are. So if you have firms that are very carbon intensive and that the market perceives that they'll be out of business in 5, 10, or 20 years unless they become green, then these companies have to pay a higher rate of return. These are called carbon risk premiums for investors to willingly hold their stuff. So really, and the market is already divesting away from those carbon intensive firms, whether they're oil firms, whether they're steel firms, aluminum firms, or whatever. So here you see that these risk premiums that they have to pay, these carbon premiums, they have to pay extra for investors to willingly hold them. Again, all before the war. And so what you also find is that as climate awareness increases, there's a better pricing of the green transition. We also see this with banks. Banks also price in that policy risk. So again, this is the other side of the medal of compensation, so that banks are really disciplining firms that if they borrow something for a carbon intensive project, they have to pay a substantially higher rate of interest on their loans because the banks price in those carbon risks. So if the market is pricing all these risks, what does that mean for our compensation schemes? And are they necessary? And if they're necessary, how does it affect the amount of compensation? And I'm still thinking about it thanks to this panel. So I finish off with some policies. So the climate policy relevant sectors, some estimates have put it at about 40 to 45% of equity portfolios and pension and investment funds. It's big potatoes, it's a large chunk. And banks are most exposed via fossil and utility via loans. And then all these risks get amplified in a network of interconnected financial and actors, and also a network of firms. So we should also be interested how these risks affect the financial assets and particularly the stability of the financial system. And that's why this whole issue has a lot more attention among central bankers than among governments and ministers of state. So my policies would be to commit to a safe carbon budget, these 400 billion tons of CO2. Do that by having quite a high carbon price, say $100, $120 per ton of CO2. Let it grow 3.5% per year. Absolutely crucial that you announce that for the next 30 years and that tie your hands to the mast, so that there is no uncertainty about it and that you avoid all these regulatory risks. You should also help households and producers to switch to breakthrough carbon-free technology. You do that by leveraging peer effects and learning by doing effects. So you shift the equilibrium from a high emissions equilibrium to a low emissions equilibrium. So it's always carbon pricing, and together get the technologies, get them changed. You want to avoid a disorderly green transition. People are quite well aware of it. So government should be, they are typically well known for changing their mind all the time. That's also part of the electoral system. So we should try to avoid this disorderly green transition, to avoid these risks, and then presumably also to avoid those compensations. So a few comments on the point of this panel. There will be litigation claims. So if policy, particularly if policymakers, and I know this from the Netherlands, have incited firms in the past to please invest in carbon investment projects. Sometimes these projects have even been jointly financed by the government and particular companies. And then if the government unexpectedly reneges and changes their mind, and then say that these projects have to close down, then of course that is indeed time inconsistent. There will and there should be litigation claims. So that's really, so to have these compensation claims, the way I look at it, is a way to punish the government for being time inconsistent. It's a way to incentivize the government to have a clear strategy for the next 30 years and then to stick to it. It's already been pointed out that it goes back to many people in the past. There's a huge literature on it. With the risk of expropriation, there will be hold-up problems in investment. And then the investment problem, there will not be enough investment in the green transition. And that's a big problem from that point of view as well. It's already been pointed out, and thanks to our first speaker, if there is unfair, inequitable, or unlawful treatment, there will be compensation. But I liked the one in preparing the thing. I liked the spirit improving role by Emma and Jonathan, and then the key question is, who bears the regulatory risk? Should it be the state? Should it be the household? Should it be the firm? I think such a rule, and I think there are ways of improving on the rule, but that's not for here. I think the principle of the rule is very clear. But to stick to something like a rule and to stick to a credible long-term green transition policy will be helpful, because if you don't have something like these two elements, it will undermine the trust in the legal system, as Jonathan very clearly explained. But then I have the question, what if these type of risks are already priced in by the market? What happens to the portfolios, institutions, and other investors? How about NGOs and activists taking carbon intensive firms and governments to court and holding them to their promises to become carbon neutral? So I will leave it at this, and sorry for taking a moment more time. Thank you.
Thank you very much, Rick, for your insights. Let me turn to Boaz as our final speaker on the panel.
Thank you, Janssen. Yeah, so I think I'm going to speak for a little bit about the role of the quantum expert and the extent to which what the quantum expert does is relevant or not relevant to the issues we've been discussing. So let me start again. Yeah, so I think, as I said, I'm going to be modest about quantum experts. The role of the quantum expert is in a sense, well, it is quite limited. So the quantum expert is given a legal standard by which compensation should be determined, and their job is to do the technical work of applying that standard. And I've now learned that this is an extremely naive view, but the practitioner's perspective is essentially that it's always causal factory, that it is determine the compensation that would leave the investor in the financial position they would have been in absent the breach, assuming there is a finding of a breach. So in a sense, it can be quite humdrum, and then I'm going to come to a number of reasons why I think there are still interesting questions that are relevant to this debate. But to first of all say a little bit about issues that I think aren't issues for the quantum expert. You know, we've had some debate now about whether DCF should be excluded so discounted cash flow methodology should be excluded as a way of assessing damages. And I would say that if the legal standard remains, put the harmed party back in the financial position it would have been in absent the breach. So in the case of an expropriation, if the legal standard is give them the market value of the expropriated asset, then it doesn't make any sense to preclude DCF, because DCF is simply a methodology and is generally the preferred methodology for determining the market value. So in the case of Rockhopper, which I had no involvement in, I've just skimmed honestly the decision. Everyone used or made reference to the DCF methodology. The tribunal eventually relied on a DCF assessment that was one that Rockhopper themselves had made for their own internal purposes when they were doing the acquisition, and which gave a lower damages figure than the one that their expert put forward. So I don't think that the issue of DCF was particularly relevant there. I think there are obviously complicated and difficult issues in Rockhopper, but they're not complicated and difficult quantum issues. As far as I can see, there was nothing wrong or particularly interesting in the Rockhopper case from a quantum perspective. So having said that, then what are the questions that I think are interesting in relation to what quantum experts do? And I think there are two types of question. So one is, are we missing something in the way we apply the legal standards? So are there things about climate change that somehow quantum experts are routinely not taking into account when they do their work? And the second one is, if the legal standard were to change, how would we, I mean, I'll use we just for shorthand, how would we go about implementing that? And are there practical difficulties in certain possible changes in the legal standard that might be considered desirable? So that's a kind of a framework. And let me discuss then 4 specific issues, and they're roughly speaking go from the kind of least radical to the most radical. So the first one relates to stranded assets, and I think this is, I mean, it's a fairly straightforward question in a sense. So is there a possibility that that quantum experts and the investment tribunals who rely on them are routinely overvaluing fossil fuel assets because of misunderstanding or underestimating the stranding risks, and therefore simply saying they're worth more than they really are worth? So, for example, and all my examples are going to be entirely hypothetical. Suppose that you had finding that there'd been an expropriation of a refinery somewhere in Europe, and the valuation was based on the refinery being in operation for another 20 or 30 years, maybe, and was based on standard projections of prices or refining margins or whatever. Maybe that's all a terrible mistake, and everyone who's involved in these kind of valuations doesn't understand that electric vehicles are coming very quickly, and that demand for petrol and diesel is going to crash, and that the refinery would have gone out of business in 5 or 10 years' time. That seems to me it's an entirely normal problem. It's just it's not a conceptual problem. It's just a sort of question of fact and of doing a good job. I'm not sure that there's anything more to say about it really, except, well, there's one more thing to say about it, which is, even if the markets as a whole are underestimating stranding risk and therefore overvaluing fossil fuel assets, those still are the current values. So if I own a fossil fuel asset and I and the market and everyone else thinks it's worth more than it really is because we don't understand the impact of the transition or the speed of the transition, I could still sell it today to someone else who's making the same mistake that I am, and I would therefore get that price. So in terms of what have I lost if that asset is taken away from me, I've lost the opportunity to sell it at this price, even if this price is in some sense inflated. So I think that it's obviously hugely important as a practical matter, and the issue of stranding is hugely important for the financial system. I'm not sure that it's really important for investment tribunals, and I can't really imagine that a tribunal would be willing or would be wise to stand up and say, we three lawyers sitting on this tribunal have decided that the capital markets are overvaluing fossil fuel assets, and we know better. Second issue then, are we going wrong? Are we using the wrong but for in cases where governments' climate policy is alleged to be a breach of an investment treaty? And I think hopefully we'll have time to discuss a bit more Jonathan and Emma's proposal for a different but for, because I had not come across this until now. It seems super interesting to me. I think I had in mind something a bit different, a bit less conceptual, but to give an example, suppose that a government closes down a coal-fired power station because it's causing tremendous harm to the climate, and that's found to be a breach of an investment treaty, and the most common approach would be to say the counterfactual is you don't close it down, but maybe the correct counterfactual is to say, well, it would have been reasonable and would have been, and this would be a finding of law, not a quantum question, but it would have been reasonable and consistent with the treaty for the government over time to impose requirements such as the progressive addition of CCS, carbon capture and storage technology, to the existing plant, which would have imposed considerable additional costs. Should we be using that as the but for? Now that does seem to me very interesting, but I think that is a question of law and of fact. I mean, some of the facts would be about whether it would have been foreseeable that the government in that case would require the progressive introduction of CCS. So I think that's relevant, but as I say, I don't think it's really primarily a quantum question. A third question, which I haven't seen discussed, but I do think is potentially interesting, is suppose the government takes action which reduces carbon emissions and therefore has an impact on global warming, and suppose, for example, that they close down or prevent one of these carbon bomb projects we've just heard about. So a carbon bomb project, as Rick said, would produce over 1 billion tons of carbon dioxide, and that, I mean, the damage, all these figures are very hard to quantify, which I'll come back to, but the damage for 1 billion tons of, the damage to the world for 1 billion tons of carbon dioxide at a commonly used number might be $200 billion. Well, suppose that the investor is a company whose shareholders include large numbers of pension funds, which have huge numbers of beneficiaries themselves. If we could do a massive kind of repeated piercing of the corporate veil and go back to the shareholders, then you may have millions of people and they will get some benefit from the reduction in global warming as a result of this. So should that be taken into account? If you want to leave the investor in the same position they were absent the change in policy, if we can interpret the investor as being the ultimate owners, so the natural persons, and if we can interpret the position as being not just their financial position, but the quantifiable health and other kinds of benefits they get from avoided global warming, then should that be incorporated? And I think there's an obvious first question, which is, would that ever be a material benefit? Now, in many circumstances not, but I think in some circumstances, and I've just done sort of back of the envelope thinking, maybe it would be. And certainly, as if we hope this doesn't happen, but if the global warming, global heating crisis becomes worse, and the incremental harm from CO2 becomes greater and greater, which I'm not to downplay it, but imagine it becomes even worse, then maybe this does become something which is quantifiable and material in the future. The second question then would be, how quantifiable are these benefits? And that is quite difficult. So there's a lot of very serious work that's done in quantifying the the social harm from carbon emissions. And I think it's fair to say that there's a very large range of figures. So there's a paper last year in Nature, which is, I think, a sort of a very good summary of where the current research, and that has a reasonable range which goes from $40 to $400 per ton of carbon dioxide. So we know that emitting greenhouse gases is tremendously dangerous and harmful, but exactly how dangerous and harmful is putting a number on it is really quite difficult, and that would obviously be a challenge. But on the other hand, generally valuing things and putting a figure on future profits, losses, and harms is accompanied by uncertainty. That's the reality of doing the job of estimating compensation and doing valuation. And fourthly, the sort of most radical question: suppose that you did change the legal standard significantly. So the example that I had in mind was if the legal standard were to take into account either the past or the future, or both, social harm caused by carbon emissions. Is that something which could be incorporated from a practical point of view into the work of valuation? Now, is that example something which is likely to happen? I don't know. It seems to me a bit unlikely, but that's really outside of my scope of expertise, for sure. But suppose, for the sake of argument, that it did. So the government shuts down a coal-fired power plant, then the compensation is required to somehow take into account the harm to society that its emissions would have caused, and maybe that would be part of a balancing approach. Would quantum experts be able to quantify it? And I think that brings me back to what I've just said in discussing the third question. There is a great deal of uncertainty in those quantifications. They range enormously. So as I said, figure of $40 per ton and $400 per ton as measures of the harm to society, harm to humanity from emitting a ton of carbon dioxide, are both within a reasonable range. But again, as I said, I think that's not the only example where valuations are extremely uncertain, and generally quantum experts will present a range of figures and explain to the decision makers what are the choices they would have to make to put them at one end or the other, or in the middle of that spectrum. And for example, one of the big causes of uncertainty about the dollar value of future harm from global warming is the discount rate, the extent to which we discount the harm which occurs in the future. That has a big impact on this figure, and that's no different from any other kind of valuation where the discount rate almost always has a big impact, and is often the subject of a lot of contentious discussion in investment treaty arbitrations. So I think I'm going to stop there and make room for discussion.
There we go. Thanks very much, Boaz. And thanks to all of our speakers for their presentations, for their ideas, for their thinking. We've generated quite a lot of questions in the chat, and I'm grateful to our speakers who have been answering many of them. We have far more questions there than we really could ask, even if we wanted to, in the time allotted. I just want to offer one observation or one thought about this issue, and I think, frankly, it seems that it's applicable to many of the legal questions that accompany the revisions to the way in which our economy works, the way in which we live our lives, in order to get to Paris Agreement commitments. And that is, a couple sitting and saying, oh, the house is burning, and the other one saying, yes, let's talk about it. Great ideas. We have great ideas. We have proposals, but in principle, I'm not a scientist, but as I understand the sciences, we don't have a great deal of time. So to the extent that these are issues which need to be dealt with in a time-sensitive manner, I'm frequently struck by the fact that I don't at least have a great deal of faith that they can be, given the coordination difficulties among states on some of the most basic questions. So in terms of practicalities, I guess what I'm interested to hear is setting aside optimal changes, like perhaps changing treaty language. Are there things that tribunals and litigants, and especially states in litigation, can do right now to make arguments to tribunals to try to incorporate some of the ideas that we've been discussing? I mean, even if it's a bit out there to suggest to a tribunal under current customary international law that they should adopt Emma's and Jonathan's suggestion, are there things that they can do or arguments that they can make arising out of that thinking now, until we get to treaty amendments and so on and so forth? Perhaps I could just throw that out to the lawyers on the panel, but also to our other speakers. All right, I'm going to call on somebody. Martins?
Sure. So I mean, and I think our focus, so the focus of my response will be on the law of state responsibility, but I think that more generally, and I will not go into detail on that, but I think that international law provides sufficiently sophisticated vocabulary for variously taking into account developments in other fields of international law. Investment law is an island, but it is not an isolated island, and things may be appropriately taken into account, whether through principles of treaty interpretation or appropriately determining the content of applicable customary law. And I think in many ways, the things that one might sometimes be particularly concerned about regarding investment law, namely vagueness of certain rules, is in the setting of engagement with other fields of international law a certain benefit, because it suggests that other rules might carry greater weight in the interpretive and application process. But that is by way of background. So I think that international law is more sophisticated on the point. Well, I mean, naturally, it is not surprising that I think that my proposal is the bee's knees for precisely the reasons that you suggest. So it seems to me the sort of an argument that it is conceivable that if a sufficient state practice were to accumulate, that it could be read within the existing law as an exception or a qualification to the principle of full reparation. So my thinking when I was drafting it was to suggest that even if it is not reflective of current law, if sufficient state practice were to accumulate, it would not be systemically ill-fitting. Now, in that sense, I'm agnostic on the lawmaking process. Ultimately, it is a question whether states do find it helpful, whether states do invoke it or not. I know that my work has been invoked in other judicial settings, Inter-American Court of Human Rights and International Court of Justice, because we do not really see the transcripts often ever, but at the very least, after the end of the cases, I don't know whether these things are taking place in investment law. I know that there has been a bit of traction in UNCITRAL. Now, that is an attraction for customary law, because if customary law is formed, and investment arbitration is usually not providing for special rules of customary law, it would have immediate applicability. It is something that would not need to filter through the political processes as it were at the treaty level. Now, I think that Jono made a couple of excellent points of why one should be cautious about my argument. So are we, do we really trust the sort of decision makers that international law and investment law has to deal with such a complicated and sensitive proposition? And I completely take the point, as in many old jokes, this is certainly the place I would start from in an ideal world, but from a different, broader perspective, that is how international law normally works. We trust a decentralized international legal process to deal with vague and hugely important rules in law of the sea and freshwater law, and international law has broadly been decent with that. I think the argument by analogy that I would see is the principle of contribution to injury, something that is not determinable in a priori terms, but really through the practice of application and fleshing out of various examples. And in that sense, I think it has certainly been less problematic than people might have accepted. So I'm not downplaying the costs at all, but it seems precisely with an eye to speed and systemic fit, a legal proposition of this sort might get in there more quickly. I think that there might also be more receptiveness to a technically legal argument. I really enjoyed Emma's and Jonathan's paper. I guess the question is about the extent to which tribunals would be receptive to an interdisciplinary normative benchmark as an argument in their decision making. And it's a bit hard to determine because tribunals don't speak about these things much. There's one great line in Perenco Award, chaired by Judge Tomk in paragraph 69, where he is very scately dismissive of the law and economics analysis and says that it is completely irrelevant. And I guess, you know, there are cases like Enron where the decision was set aside because it was viewed as relying too much on economy. So I suppose my sort of perhaps the converse concern is about the receptiveness of that in the lawmaking process. So in short, I think there are things that could be done already within the system, taking seriously issues on contribution, loss, injury, causality, sort of Pekasado too, and those sort of authorities. And there are ways of thinking through how it goes through the system. Probably the very last point that I want to make, and I know perhaps I've been a bit too long, but on to the kind of the question of, you know, whether I'm being a bit too dismissive of Chorzo. And I think paradoxically, the problem, I think, with investment arbitration is not that it is taken law not seriously enough. It is perhaps that it's taking law too seriously. State responsibility has been expressed agnostically towards institutional framework. And of course, we know that in reality of international law, Chorzo factory in its pure undiluted investment arbitration form applies in extraordinarily rare circumstances, because there are all those reasons that modify it. States will very rarely actually invoke it directly. In the biggest cases that are decided in international law, we have initial setups, Iran-United States Claims Tribunal, Iraq Claims Commission, where we have delineated cases. We have institutional settings that mediate these matters politically. So investment arbitration is in that sense unique, in that it is one of the rare cases when it's really the grand purity of international law faced with reality. So that might be correct law, but I think that there is, I suppose, really the systemic uniqueness of its application, its undiluted form suggests some, I suppose, systemic openness to flexibility in the matter. Is that the ideal world? No. Is that better than all the other arguments? That would be my take on this.
Thanks, Martin. So I suppose sometimes a lack of dilution can lead to an overdose and death.
Maybe,
John?
yeah, if I'll just come in very quickly on that. So obviously we've made a case for a different approach, but I think you're quite right, Janssen, that we need to push on this in every way we can. I mean, even investment treaties is a very small part of the climate change picture, but even in as far as we're talking about investment treaties and their interaction with climate change, if we take the standpoint of a litigant in a particular case, there's a completely different set of considerations. You're thinking about what arguments can you mobilize for that tribunal rather than the way we think about it, which is more at a system kind of change levels. So you've got all your arguments about the Paris Agreement as part of the applicable law, or at least something that can be taken into account as other rules of international law applicable between the parties in the relationship. If you get to the stage of compensation, so you can't make these, or you unsuccessfully making these climate change arguments on the merits, I think, Boaz, if I understood you correctly, you had a lot of really interesting ideas there, and I would hope that states will be making these arguments a lot more vigorously. So things about, even if the tribunal is attached to the current but-for scenario looking forward, then what are the regulatory parameters that should be built into that scenario? If we're being realistic about what the but-for scenario might be in the absence of the breach, it still might involve a lot of regulatory change. It might involve global movement towards a Paris Agreement that could include very high and graduatingly increased price of carbon. So these sorts of arguments can be reframed and made intelligible within the language of the existing system, or can be made to some extent to join onto those concepts. But I think that's not, that's something that litigants should be doing in the current system, but that's not a reason for also pushing on wider system reform at the same time.
Emma, did you want to come in on that?
I'm very happy to claim total ignorance on the legal system and how we get this implemented. My hope is that the more clever lawyers I explain our idea to, the more clever people there will be trying to figure out how to get it done in time.
I mean, I guess one thing, Boaz, sorry, I didn't see if you were unmuted or not. Do you have something a comment?
I mean, really, just to say, I do think that this question of what is the right counterfact within the existing framework, as I understand it, is, speaking as someone who has been involved in the policy world, it's reasonable to think that an investor would know when they make an investment that as new information becomes available, policy will change. And that seems to me to be the starting point for thinking about what's the right counterfactual.
I mean, just to circle back, and the link between the law and the economics and the quantification exercise. I mean, looking at the way in which the ILC articles were written, particularly in Article 36, I mean, I think, I'm not going to cast aspersions, but in a sense, we've set ourselves up as lawyers for the tail to wag the dog by framing such very broad standards and then effectively turning it over to experts in other fields and saying, can you please turn this into a number for us? And leaving the guidance very broad and general. I mean, I guess from the perspective of policymakers, it's an open question as to why states have been so slow as in addressing the issue of compensation and damages in their treaties. And I guess in that respect, Jonathan, Emma particularly, but I mean, what's the right platform in order to get states to engage with this and to do so in a meaningful way that can address the issue across the more than 2,500 treaties or so that are still in force?
I'll have a go, maybe, Emma. So, I mean, the politics of change is very difficult. We saw that with the Energy Charter Treaty, where actually a very small number of holdout states were able to prevent the more sweeping reforms that the European Union was trying to get up. And then the consensus position they obviously got was not satisfactory for a whole bunch of EU states, which are now signaled that they're withdrawing. So we know from that any consensus instrument is going to be very difficult to do. There needs to be a multilateral process, though. Ideally, it needs to have an opt-in architecture. The obvious place for those discussions to happen is UNCITRAL Working Group 3, because that's where they're happening at the moment. Another possible forum is the OECD, because it's driving this discussion on investment treaties and climate change at the moment. But there's a historical, I think, legacy from many developing countries of mistrust around that, and they're not directly in the room anyway. The obstacle with UNCITRAL Working Group 3 is the current interpretation of the mandate. That's a potential obstacle. There are a bunch of states and also civil society actors outside the process pushing on that. I think there is a genuine appetite for engaging the question of compensation and damages in that forum, in a sort of discussion that bridges the so-called procedural substantive distinction. But, you know, everywhere where people are moving, they could be moving on this. So that also includes FTA negotiations, other fora as well. Emma, I don't know if you've got any thoughts.
Just one quick thought, just because that's what I'm writing about at the moment. There are a lot of very complicated regulatory collaboration and regulatory questions around the net zero transition. And one of the ways that states are dealing with those is part of this shift away from multilateralism, which is unfortunate when you've got thousands of treaties you're trying to change, towards bilateral and plurilateral, what I would refer to as green economy agreements. And perhaps because these are actually have a mandate, at least from the Australian government, and I'm pretty sure from Singaporean as well, to try and be innovative, they're not a bad place to put an innovative proposal. Just kind of slip it in there and then let the impacts start rippling through the system.
Martins, yeah, go ahead, please.
Just a very brief reaction to what you said about ILC and Article 36. It's an important point whether Article 36 is a problem, and I have given it a bit of thought. And there are many people who think that it is, precisely for the reasons that you suggest, that it doesn't really tell us anything on the important points. I think that Rosalind Higgins, Christine Gray, and Dina Shelton were of the same mind. I think ultimately it was the right call to make. The ILC formulated the general principle and left the development of the best practices of valuation in different fields of development in state and judicial practice. Imagine the alternative. It would have set up the best valuation practices in investment disputes, environmental disputes, human rights and humanitarian disputes of 1999. How is that better? So I think that was correct, and I think it has worked reasonably well elsewhere. So I think the right way to think about it is to think about the practicalities of application and what the best ones of them are. And ILC's articles are absolutely open to that. The second point, instead of thinking about Jonathan's suggestion of where to do it, I think that there is an interesting PIL question of whether we are elaborating a rule relating to content of responsibility in cases invoked by investors, or we are speaking to the ILC articles more generally. Because I can sort of feel that if it is a specialized issue, that might be dealt in one way. If this is an issue that simultaneously formulates views on war claims, for example, or something else, because if it is state responsibility, it is state responsibility for all the other breaches, that I think at the level of states might require a little bit more of buy-in than just the investment department delegates. So just 2 cents, not necessarily providing solutions, but just footnoting.
I mean, just to come back on that briefly, Martins, you mentioned in your article the direction that Arancho Ruiz was going to take the articles in terms of this concept of excessive onerousness. I mean, again, that's something that might have been in the articles, but ended up being dropped. Is there space, do you think, in the articles to interpret what we do have as encompassing such an idea as a mitigator for the application of the rules in their undiluted form?
So at least in my article, I think I just tried to be very honest of my understanding of what the law is and what requires to change. And I think we cannot say that there is an implied exception of crippling compensation. Crawford took and defeated it explicitly. So I think it would be indefensible to say that it is there. So therefore, my claim is that it is not something that is textually consistent with the ILC, but creating such an exception might be consistent with a broader balance and logic. So it is not there, but putting it there would not do violence to the project. So it's not something alien. It was simply a policy call not to have it there in that way.
Well, it's quite clear that I'm showing my my lawyerly skew away from economics, but perhaps I could turn to you, Rick, and then to Boaz for comments that you might have based upon what we've been talking about so far.
So first of all, I'm a complete layperson compared with all these eminent lawyers speaking here. So particularly, I mean, I have experience I was a government minister for a while, and I did work with international treaties there, and a lot of particularly the World Heritage Treaty, and a lot of the comments being made here, I see reflected in those international discussions, and I feel it's a thing we as economists are terribly bad at. So great for Emma collaborating with lawyers to do this stuff and try to get somewhere. Having said that, and having read, there were 2 articles by Emma and Jonathan. I read one of them, so maybe it's in the other article. I think the principle of going in that direction is good, but I think in the end, the proof of the pudding is in the eating, and that's really how much will the compensations be. And there I see a lot more work needs to be done. So I already said they may be clobbered because there's changes in technology. Maybe there's certain, solar energy and wind energy are huge reductions in the cost per unit of energy. So maybe they're being stranded because of technology rather than by government. And thirdly, there may be changes in social norms. And so you want to disentangle that. Secondly, are the assets they've invested, can you still use them for something else? So, for example, the assets in the Ruhrgebiet, that's the main industrial part of Germany. A lot of them have been reused again for creative industries and things like that. So it's not all written off. So something how you can repurpose investment assets is a crucial part of the story, and also in the calculations. And thirdly, I think that you need to see, well, it's all about the intention and what the government has actually done. I mean, we all know that we have to go to net zero. I mean, all countries have committed to that. So we know that although the government may not quite have got their act in order, we know that there's a pretty high probability that they will have to get their act in order in the next 5 or 10 years. So I don't know what that means legally, but to me, from a common sense point of view, it's not there yet, the policy in place, but that it will be in place soon. It's almost 100% because they if it's not 100%, they'll be taken to court by Agenda and other NGOs, both companies and states, and they'll be forced to take the actions to which they've committed themselves to. So then again, so maybe I'm too much of an academic, but then I was reading the paper on the hold-up problem and the pre-to-improving rule. What do these points, those 3 or 4 points I just made, what do they mean for when you actually then started doing the calculations? But that's just being finicky. I just think it's a bloody good proposal, and I think we just need more work on it. But both empirical and a little bit of theoretical work as well.
So I know we're very close to closing. Can I make one very brief intervention? And thank you. Firstly, enormously, I'm overwhelmed by the positive response, but very briefly, yes, all of these valuation issues about environmental as well as, economic valuation, they don't all magically go away under our proposal. We will need to work through them, but they're actually a lot smaller and a lot less common than under the current regime or under something like a Michele-Ferguson type rule, because there is less cases in which compensation gets paid.
And if I can make a last intervention very quickly, I want to go back to something I think Emma started with, which is the purpose of these rules. The reason why we have investment protection is not to be nice to capitalists, it's to promote investment. And I do think it's important to make sure that whatever rules we do have still do promote investment. So to give a really quick hypothetical example, let's say I have a foreign investor who I would like to build a nuclear power plant somewhere in my country, and there's a lot of local opposition, and I, as the government, would like to be able to say to them, I can commit to you that I won't change my mind and close your plant down or stop halfway through when you've already sunk in maybe $500 million or $1 billion in investment. And I do think that the aim of having the investment treaty is to enable governments to be able to make that kind of commitment. And I think therefore any rule that one does change to needs to still enable the government to make that kind of commitment. And I wish we had more time to talk about this, because I would worry with Emma and Jonathan's rule that in that case, the government's benefit, if it did change its mind later, wouldn't be a financial benefit. It would be a political benefit, if you like, that they'd made some people happy locally, and therefore that wouldn't, if I understand rightly, give rise to compensation. So we do need to do this, because one thing we do know about the transition is that it requires trillions of dollars of investments, and therefore we do need to continue to promote investment.
Boaz, I'm going to give you the last word, because we're at our 2-hour mark, 7 p.m. here in Singapore. I want to thank everyone on the panel for their time, their presentations, their thinking. This has been really fascinating, really interesting for me, and I'm sure for our audience as well, and I hope as well for you, our panelists. So without more, let me thank you once again, and simply remind those in the audience that our seminar series on climate change and investment continues with our third seminar on the 15th of March. And in our third seminar, we move away from the questions surrounding investment protection and how states manage their obligations and deal with claims under investment treaties. And we actually move towards how do states attract investment, investment facilitation measures for green growth, both at the domestic level and at the international level. And Emma mentioned the Green Economy Agreement between Singapore and Australia, exactly that kind of agreement, as well as the work that's ongoing in the WTO. So please do tune in for that. And again, thanks to all of our speakers. Have a good evening. Yes, thank you, Rayla. Rayla's put the link in the chat. But thanks again. Take care all.